Monsieur le Commissaire, bienvenue.
Welcome, Commissioner.
Avec votre équipe.
Welcome to you and your team.
Vous pouvez peut-être nous représenter votre équipe, ceux qui étaient là l'autre
If
jour,
you wouldn't mind introducing your team again. I know you were here the other day, but still. We'll proceed as follows. In the first hour, we will hear you on your annual report for 2015-16. And in the second hour, we'll hear you on your special report on Air Canada. As usual, of course, there will be rounds of comments and questions by committee members after your presentations. I would remind everyone that this meeting is televised. Commissioner. Thank you, Mr. Chairman. I am here with the Assistant Commissioner, Policy and Communications Branch, Mary Donaghy, Pascal Giguère, Director and General Counsel of the Legal Affairs Branch, and Ghislaine Salkali, Assistant Commissioner of the Compliance Assurance Branch. Good afternoon. I'm very pleased to appear before you to provide an overview of my 10th and final annual report, which I tabled in Parliament on May 19th.
This annual report covers a range of issues that have emerged or been dealt with over the past year. Some issues reveal the progress or lack thereof over the 10 years that I've been Commissioner. These include immigration, equality of service, early childhood development, and the significance of bilingualism at major national events, to name a few. But two issues in particular stand out. Tout d'abord, il est évident qu'il existe un problème.
First, it is clear that there is an ongoing problem in the area of access to justice in both official languages. Canadians who seek to be heard in the official language of their choice in our courts face barriers that are sometimes impossible to overcome. Lawyers often feel that they have to warn their clients that if they insist on exercising their right to be heard in their preferred official language, the legal proceedings will take longer and will cost more. One reason for this is that the bilingual capacity of the Superior Court judiciary remains a challenge in a number of provinces and territories. Those who apply for judgeships and self-identify as bilingual do not have their language skills tested. Once they are on the bench, they often discover that they are unable to preside over a trial in the second language. The previous federal government resisted taking action to implement the recommendations I made in the 2013 study on access to justice in both official languages that I produced jointly with my provincial counterparts in Ontario and New Brunswick. And so, the first recommendation in my annual report calls on the current government, and in particular the Minister of Justice, to address this matter.
The second issue is one that was raised repeatedly by former Senator Maria Chaput, as well as by numerous community leaders. It's now been taken up by Senator Claudette Tardif in the form of Bill S-209. For decades, federal services have been delivered in both official languages in different parts of the country, where there is significant demand for services in the language of the minority. A minority community can be thriving and growing, but if the majority grows faster, services are lost. This is simply unfair. A community's vitality should also be taken into account, not simply the rate at which the majority community has grown. Bill S-209 provides a way of addressing this injustice, as would a revision of the official languages regulations. In 3 years, we will mark the 50th anniversary of the Act, and planning should start now to conduct a review of how Part 4 of the Act, which deals with communications with and services to the public, is applied. The second recommendation of my annual report calls on the government to make this a priority. Entre-temps, dans le milieu du travail fédéral, en 2015,
Meanwhile, in the federal workplace in 2015-16, complaints under Section 91 of the Act about the language requirements for public service positions increased by 13% compared with the previous year. One of the reasons for this is a long-standing disagreement between my office and the Treasury Board of Canada Secretariat. The Secretariat advises institutions that a BBB linguistic profile is appropriate for most supervisory positions, while I continue to insist that CBC is the minimum level to ensure clear and effective communications with employees in regions that are designated as bilingual for language of work purposes.
Along with tabling my annual report before Parliament on May 19th, I issued new report cards that rate 33 federal institutions on their compliance with the Official Languages Act. I also released a report on my role before the courts over the past decade. Yesterday, on June 7th, I tabled a special report to Parliament that proposes options that should be examined by the federal government to ensure that Air Canada effectively meets its official languages obligations. I will present this report to you later on today and will answer any questions you might have at that time. During the course of my 10 years in office, I've delivered 528 speeches and intervened in 23 court cases, including 9 before the Supreme Court of Canada. My office has processed 7,156 complaints. Lorsque je regarde vers l'avenir, j'ai néanmoins...
As I look ahead, one thing worries me, though. Sometimes I get the impression that the attitude towards language policy is, it goes without saying. And so we don't talk about it, but we have to talk about it. For if it goes without saying, it remains unsaid, and what is unsaid is often neglected or forgotten. In that context, I would be remiss if I did not say how pleased I am that the Royal Military College Saint-Jean is to regain its status as a university. For more than 2 decades, Canada's armed forces have suffered from the absence of a French language military university, and this corrects a serious problem.
This year, I will present my 8th Annual Award of Excellence to Canadian Parents for French for its outstanding contribution to the promotion of linguistic duality. I congratulate the organization for its exceptional work and for respecting French as an integral part of Canada. Les célébrations de l'anniversaire du Canada.
The Canada 2017 celebrations also offer a unique opportunity to showcase linguistic duality. Numerous groups throughout the country are hard at work organizing events to mark our sesquicentennial anniversary. Linguistic duality must be a key component in all of these efforts.
I commend the honourable members of this esteemed committee for your continuing efforts to promote and protect our official languages. I thank you for your attention and would be pleased to answer any questions that you have.
Merci beaucoup, Monsieur le Commissaire.
Thank you, Commissioner.
Pour votre présentation.
Thank you for your presentation.
Puisque l'heure avance, on va commencer vite
Since
rapidement,
time is
avec,
moving on, I will begin with Ms. Boucher.
Bonjour, Monsieur
Good
le
afternoon,
Président.
Mr. Fraser,
Bonjour,
and good afternoon
ceux qui l'accompagnent.
to the members of your
C'est
team.
toujours un honneur de pouvoir parler
It's
avec
always an
vous,
honor
et,
to have an
on
opportunity
sait
to
à
speak
quel
with
point,
you, and
votre travail
we
depuis
know
ces
the
dernières
extent to
années
which your work in
a
the past
été,
10 years has
je vous salue d'abord
been
parce que
instrumental.
vous
I
avez fait un très, très bon
raise my
travail
hat to you
pour les
because you
langues
have done
officielles.
such excellent work
Pour avoir été là un
for
peu
official
avant
languages.
aussi, on revient toujours souvent
We always come back
aux mêmes questions.
to the
Donc,
same
on
issues,
s'aperçoit qu'il y a pas
and we
grand-chose qui a
notice
bougé
that
parce qu'on en
sometimes
parle encore
not much
aujourd'hui.
has changed
Donc,
because we're still talking about the same issues
Moi, je
today.
voudrais savoir une chose.
I would like to know
On s'aperçoit
one thing.
que
We
pour promouvoir
note
le
that in
bilinguisme
order to
à
promote
travers le pays,
bilingualism across Canada,
c'est d'abord et avant tout, si on l'entend souvent, ça
as
part
we've
de
often
nos
heard,
institutions fédérales.
our federal institutions have to be front and center in the effort. In your report, we see that Radio-Canada is lacking and has been lacking in the time it takes to respond to an email in French. It takes twice as long than for them to respond to an email in English. Federal institutions, in my view, should be accountable to us, and that's something we've been talking about for years. As you said in your report on Air Canada, do you feel that penalties should be established so that people and institutions understand the message? In the report that we tabled yesterday, sent to the speakers of both houses, a special report to Parliament, we put forward a series of options for Air Canada. I think I'd rather discuss that later when I present the report. There is a series of incentives that we put forward for you to discuss. The issue is a complex one. There's a range of possible options. And these range from agreements to fines. In any case, I think I'd rather leave that detailed discussion for the second hour once we have come to our second topic. But there's a great deal to discuss in terms of the discussion between the federal government and the person receiving the service, the individual receiving the service. There's been a decline since 2006, and in the report card they're getting between 0 and 50%, many institutions. In your view, what measures should be established to improve service, both for the federal employee and for the person receiving service? Well, coming back to the report cards we prepared on 33 institutions, we saw an improvement in some institutions and declining performance in others, but only one institution had a performance we described as weak. No institution was exemplary. But overall, there was a slight improvement. Yesterday, I was at an event where an employee of a federal institution came up to me to say how deeply she'd appreciated the rating her institution had received, that it was a B, and she said they'd started with a grade of E and now they were at B, and how much work the institution had invested. She felt very happy about this, and that helped me realize that there are officials and champions, official languages champions, people responsible for coordinating official languages that are taking their responsibilities very seriously. The key is leadership. When there's someone at the head of an institution that sends a clear message, that's very important. We saw this at Public Services and Procurement Canada. When I started, they had a low grade. At the time, the minister and deputy minister both took that grade as being unacceptable, established an action plan, and we've seen how much progress they've made. At the time, of course, it was PWGSC. When you say that you come back and find the same issues coming back, at least that's the perception, and that no improvements are really being made, I would say that it does take ongoing effort. And this is something I say in the annual report. By definition, majorities tend not to be sensitive to the needs of minorities. That's how things are. Sometimes it's unfortunate, but that's often how things are. And even within federal institutions, the work goes on, the work of making sure that that sensitivity is there. Mr. Sampson, you have 6 minutes. Good afternoon, Mr. Fraser. It's always a pleasure to see you here. We appreciate your presence and that of your team. It's huge having been in your position for 10 years. Before putting my question, I'll take a word you mentioned, leadership. To me, leadership means that good leadership means that there have been improvements on the ground when a person leaves. It's very easy to judge if there's been no progress, and as you said, when leaders do their job, things improve. We now have 5.5 minutes out of 6, so I'll put my 3 questions to you. The first is on immigration. You mention it in your report. Second, S209, and 3, the delivery of service. You said that only 2% and even under 2% of immigrants are bilingual. How do you propose that this situation might be improved? I think it takes willingness and determination by the government to ensure that immigrants are aware of the existence of an official language community, minority official language community, and are also aware that there is support on the ground for organizations that welcome immigrants. Often we find that organizations providing support and receiving immigrants simply aren't aware that there are French schools, that there are clinics and services available in French. I spoke with institutions in a minority community 1 or 2 years after an immigrant had arrived. French-speaking immigrants told them, if we had known that there was a French school here, if we had known that there was a French clinic, well, now our children have made friends, we have a doctor, we're all set up, but had we known these services were available, we'd have gone at it differently. So it's very important to inform them. There are 2 issues there. The second flows from the first. If only 2% of francophones are 2% of immigrants are francophones, they enter into communities and become assimilated, then S209 is even more of a problem if the same criteria are kept. We need to improve it. Mr. Bryson was here a few weeks ago from the Treasury Board, and he said that he was open to looking perhaps at making some changes to the rules in order to accommodate almost all of S209. So what do you suggest regarding changes? If it's more efficient to change the regulations, then I wouldn't object. But what's important right now, there are people on Treasury Board who are doing tremendous amounts of work after every census. They look at each district and decide whether the minority community still has a 5% minority linguistic population. So it doesn't really make a difference if the government proceeds by making changes in the Act or the regulations. What's important is looking at the vitality of a community to maintain or improve service. Thank you, because it's important to see how we go about it. My other question is on the delivery of services. In your view, what deficiencies that you see could most easily be dealt with? At present, we are completing a study on delivery of services. I recommend a report on this published by my Ontario counterpart, François Boileau, that presents the history of the issue, that makes a comparison with equivalent figures in other jurisdictions and in other jurisdictions and other provinces. What we are doing we're trying not to be categorical. We're trying to see what the barriers are in federal institutions and I believe you will find some interesting answers. I have 1 more minute. In Nova Scotia, French services show that French is spoken here, or say hello in French, bonjour. I would add 80% more people are requesting services in French, so that's quite a large number. In François Boileau's study, I saw an interesting definition on what that means. The delivery, the active delivery of service in the minority language, it has to be visible, audible, accessible, present, and of equal quality as the majority language. That's the criterion. And it's very interesting. When there's a visual message, there is an increase in the number of people asking for the service or for services in the minority language because they see that it's there. Bilingual people in minority communities speak the language of the majority without an accent, generally. So there's no clear and inherently understandable indication that one can use the minority language. Mr. Choquette, 6 minutes. Thank you, Mr. Chairman.
And I want to join you also to congratulate, of course, Canadian Parents for French for their good work that they are doing. I met with them also, and I know that they are passionate about French immersion. So it was really interesting to see that. Je vais maintenant vous parler. Avant de commencer à parler de justice.
Before I talk about justice and the judiciary, you know me well. You know how important that topic is to me. When Mr. Scott Bryson appeared, I appeared before the committee, that is. I asked him how far the all-of-government review on official languages had got. He said it wasn't under his responsibility, but that of Canadian Heritage. What was your role in the whole-of-government review of official language governance? I think that's continuing. What role have you played in that review? And how were you a part of it? It is still going on now. You do talk about governance in your report, but you don't mention that study. And I'm wondering about that study's role. As an officer of Parliament, I do remain at arm's length from the government when it comes to studies of that kind. So I can't necessarily discuss it in detail. What I can say on the issue of governance is that about 9 years ago, when the government had made the Privy Council responsible for compliance with official languages and monitoring of that compliance. There was its effort was to, at that point, was to limit the activities that were the responsibility of Treasury Board, and that went to departments. I was concerned because it meant that the influence over official languages might decline. At the same time, the Committee of Deputy Ministers on Official Languages was replaced by an Assistant Deputy Minister Committee at which ADMs could be replaced, rather than a committee of DMs at which no one could be replaced. Forgive me, Commissioner, but I don't have much time. I understand your point on governance, but I'd like to move immediately to your 2013 report on access to justice. It was your first recommendation when the report was tabled in 2013. You gave them until you gave the government until 2016 to implement your recommendations. How far has that implementation gone, and do you have good communication and exchange with the Minister of Justice on this? Yes, thank you. The two most important recommendations in that report were to ensure a real assessment of needs in the provinces, and secondly, to assess the language skills of those who apply to become judges, as well as entering into some agreement with the chief justices in the provinces to ensure that those assessments of language skills are made, that people are tested on their language skills. Is there anything else I should add? I'm always worried about missing important things. I had a discussion with the Minister of Justice, and we also I spoke to the Deputy Minister as well. We're also regularly in touch with the department on official languages issues. So I had a very strong impression, as you said, that there is an opening. We had taken the report off the shelves, dusted it off, and looked at it in depth. And I was very reassured by the renewed interest. I don't have much time, but you talked about posting supervisory positions and the linguistic profile. You said that you had written to the Prime Minister about your concern, and if I remember correctly, did you get any answer? There are two letters. There's one letter to the Prime Minister regarding Governor and Council appointments, and one on the classification of positions within the public service. That was a letter to the President of Treasury Board. In both cases, no, I don't have an answer yet. Thank you. Ms. Lapointe, you have 6 minutes. Thank you. Thank you for being here today, Commissioner, and congratulations for the 10 years during which you contributed to official languages. I'm from Quebec, and in Quebec, the minority is English-speaking. In my riding, I have English-speaking minorities. Should we essentially do something symmetrical in Quebec for English minorities? Should we be doing the same thing we do for French language minorities outside Quebec? That's quite a sensitive issue that concerns the Anglophone minority in Quebec, partly because the Anglophone minority has already had difficulties because of asymmetrical provisions in the Constitution. If you look at Article 23 regarding access to the school of the minority speakers, you'll see in 23(1)(a) that anyone whose first language that was learned and still understood, be it English or French, can have the right to send schools to their linguistic school. But if you go down to Article 59, you'll see that 23(1)(a) comes into force only after a resolution is passed by the National Assembly. So that provision in the Constitution means that Anglophones that weren't educated in English in Canada don't have the same access to English schools in Quebec as Francophones who arrive in the rest of Canada have to schools in French. So there is an asymmetry there.
So it's a little bit asymmetrical. And of course, once bitten, twice shy. So people are a little bit nervous about the idea of saying, well, we don't need to do anything for the minority Anglophone community the way we do for the Francophone minority community. But then on the other hand, in S109, 209 rather, there is a very broad definition of what constitutes a minority community. Or rather, if there were to be such a broad definition, the risk would be that bilingual Francophones might be defined as members of the minority community when it's actually not the case. So you're sort of between a rock and a hard place when you do this analysis. I think the important thing is to have a system that takes the real needs of the community into account. There are some areas where it might be good to have a mirror aspect. In other cases, there will be some asymmetry, but I don't think we should have an absolute rule about how we should function. Because, of course, the needs are so different in different minority communities across the country. Thank you very much for that answer. Earlier, you spoke about people who supervise federal officials and the fact that they're required to have a level B. Now, there are officials, or federal workers in my family, and some of them are exempted. In other words, they have the highest level. Then you have level A, which is bilingual, B, which is you get by, C, you don't have a very good level, D and E are very bad. So for people who want to get to a management or supervisor position in the government need level B, is that correct? Well, in the Treasury Board, we've developed a template for job descriptions, and we recommend level B for management positions, even for those that are designated as bilingual positions. But we believe that level B is not really sufficient to be able to manage people, to conduct performance reviews, and so on. And something that I've noticed, now you talked about the mirror effect. Well, sometimes I wonder if there's a difference between a Francophone working in a predominantly English environment with a level B and an Anglophone working in a predominantly Anglophone environment who has a level B. For an Anglophone with level B who's working in an English environment, he's probably not using his French. He probably passed his exam, and then there would be a natural decline after the exam. A Francophone who has level B probably speaks English often, but poorly. So his mistakes will become ingrained, and it may be more difficult for him to pass the test, even if he's more comfortable in English, because he repeats the same mistakes. So I'll just conclude with a comment. My brother spent more than 20 years in the public service. He had a management position. He started with a level B, and now he's got an E. So you're right. He was recently exempted. Okay, 3 minutes. Thank you for being with us, Commissioner. In your publication about protecting linguistic rights before the courts, you said that it's perfectly understandable for a group to believe that believing that their linguistic rights have been violated to go before the courts. But it's not understandable to see that we have so many court cases 35 years after the adoption of the Official Languages Act in 1988. I'm a Franco-Ontarian. I went through school in French. And that's partly because of the court challenges. Now, do you think that the court challenges program, the restoration of the court challenges program augurs well, or do you think that we need such a program today? Well, one thing that I'm very proud of is having conducted an inquiry about the complaints that were received early in my mandate about the abolition of the Court Challenges program. The report that we wrote after that inquiry was the only report when this matter came before the courts. We were able to participate in the case that led to the creation of the Linguistic Support Program. So with the restoration of the Court Challenges program, we hope that the definition will be broadened in order to allow more appearances before the court under the Act, rather than having constitutional challenges. Thank you. Now, concerning the Court Challenges program, you said that many cases led to policies intended to correct existing problems. So could you give us examples of bills that were created to correct such problems? Well, I don't know if I can name anything off the top of my head. Pascal, can you think of any examples of bills? I'm sure there are some, and we'll talk about them in more detail later. But in terms of there were 4 bills that died on the order paper that dealt with Air Canada. There was also one aspect that I mentioned in the report, which disappointed me somewhat. And that is that official language minority communities came before the courts to challenge a province or territory many times, and often found themselves in opposition to the Department of Justice of that region. Now, I don't know if that reflects a government decision or a bill, but I find it unfortunate that when the federal government has to intervene, that the federal government would intervene against federal language official minority, an official language minority community. Now, 3 minutes? Oh, do I only have 3 minutes? Mr. Fraser, on page 2 of your report, you mentioned that the number of you mentioned that this is the 18th time that there was a court challenge, and you said that policies concerning linguistic policies are often taken for granted. So the idea is, well, we take it for granted, so we don't need to talk about it anymore. You've been in your job for 10 years, and I imagine that over the last 10 years, when you say that you're concerned about parliamentarians and Canadians, or rather, I guess I'd like to know, who are you concerned about when people say that they take official language rights for granted? and I'll give you the rest of my time to answer that question. Well, this is a concern that I've had when I see the ministers and the prime ministers speaking sometimes. But certainly when the new government came to power, I wondered if there might be a risk that the prime minister and some of his ministers might be so bilingual themselves that they would not personally consider this an issue. For them, speaking both languages is simply a habit that they didn't even have to think about, because they had spoken both languages from a very young age, and so they didn't require any personal discipline to speak both languages, as someone who may have learned the language later might have, because other people might constantly have to think about it, like Mr. Boissonnault. So this is something I mentioned because I wanted to diplomatically remind people that even ministers and MPs who are perfectly bilingual themselves should take the question of official languages seriously. Oh, sorry. Now, Mr. Vandal, you have 3 minutes. Well, first of all, congratulations for 10 years of excellent work. I'm sure you've traveled from coast to coast. I come from Saint-Boniface, which is a francophone minority community, which I'm sure you're familiar with. Yes? So my question is, what is the key aspect if we want to ensure the vitality of French minority communities? What are the priorities for the next 5 years? What are the essential points that we need to keep in mind? Well, there are a number of challenges. There's the challenge of immigration. And when I say immigration, when I talk about immigration, rather, I often take the example of Manitoba. Citizenship, Immigration and Refugees Canada collaborated very closely with the province of Manitoba and with the Franco-Manitoban Society in creating the organization Accueil Francophone, so organization to welcome Francophones. They had enormous success welcoming and supporting immigrants into Francophone communities. And Saint-Boniface University also played a significant role in that endeavor, as well as other organizations. This is something I've discussed with the minister. The minister is very aware of the importance of immigration for minority communities. I would also mention the issue of social media. Social media and technology. There's a shift happening these days. Old communication technologies are becoming obsolete, and we're entering into a new era of digital communication. In my annual report, and in the letter that I wrote to my successor, I talked about the distinction between a linguistic network and a linguistic space. It's very important for communities to have spaces where their language is visible and used. Networks are important too, but networks are important for individuals. The fact that you can apply for your passport or your pension or reserve a plane ticket online, well, that's great for the individual, but it doesn't really do a lot for the community. So the real challenge is, how do we ensure, first of all, that institutions in minority communities have access to new technologies so that they can participate in this shift while supporting the community? And secondly, how can we use these technologies to really support the community and not just individuals? Thank you, Mr. Fraser. We're going to suspend for 2 minutes, and then we will resume with our discussion of the special report on Air Canada. So we'll just suspend for 2 minutes.
Alors, chers amis, on reprend.
All right, we are resuming. We are still here with the Official Languages Commissioner, and we will be discussing the special report. And first of all, I'd like to congratulate you, Mr. Commissioner, for this special report. It's addressed to Parliament, and it has to do with Air Canada's obligations under the Official Languages Act. Mr. Commissioner, the floor is yours. Thank you, Mr. Chair.
Report Air Canada on the road to increased compliance through an effective enforcement regime to the offices of the Speakers of the House of Commons and the Senate. The report describes the means used by me and my predecessors to ensure that Air Canada fully complies with its language obligations under the Official Languages Act. Il contient également des options permettant au Parlement de
In the report, I propose different options that would allow Parliament to modernize the enforcement scheme for Air Canada. I reiterate the need to fill certain legal voids that have existed since Air Canada's major restructuring in 2003-2004. Finally, the report contains only one recommendation addressed to Parliament: to refer the report for study to either of the standing committees on official languages.
Air Canada has always been a symbol of Canadian identity because it was built with public funds and because it has Canada in its name and a maple leaf on its logo. Air Canada has been subject to the entire Official Languages Act for nearly 50 years, first as a Crown Corporation under the 1969 Official Languages Act, and then under Section 10 of the Air Canada Public Participation Act after the airline was privatized in 1988. Depuis sa privatisation,
Since its privatization, Air Canada has gone through many financial and commercial transformations. However, as a national airline that was built with public funds, Air Canada must reflect the bilingual nature of the country and continue to meet its official languages obligations. After 10 years as Commissioner, I believe it is important to provide an overview to Parliament of the ongoing problem regarding Air Canada's compliance with the Official Languages Act.
Of all the institutions subject to the Act, Air Canada is and has always been among those that generate the largest number of complaints processed every year by the Office of the Commissioner of Official Languages. With respect to the public, a number of investigations showed that in-flight and ground services are not always of equal quality in both official languages at all points of service and on all bilingual routes. Ainsi, malgré les années et les interventions répétées,
Despite the passing years and repeated interventions by successive commissioners of official languages, the situation has not improved much. Some of those infractions involve routes where providing bilingual services would seem to be obvious, like Montreal-Bathurst or Toronto-Quebec City. After hundreds of investigations and recommendations, after an in-depth audit, and after 2 court cases, including one that went to the Supreme Court of Canada, the fact remains that my numerous interventions, like those of my predecessors, have not produced the desired results.
4 successive bills were introduced to resolve the application issues caused by Air Canada's restructuring in 2003-2004. Unfortunately, all of them died on the order paper. Ce n'est que la seconde fois dans l'histoire du commissariat.
This is only the second time in the history of the Office of the Commissioner of Official Languages that a commissioner has submitted a special report to Parliament. I believe that this issue is important enough to be considered independently of my annual report. And I wanted to provide parliamentarians with a full account of our persistent efforts over many years. This is not a single-year issue. I also had many other matters to address in my annual report, including 2 important recommendations to government.
Enough to make recommendations following investigations or audits, nor is it enough to report on Air Canada's compliance in annual reports to Parliament. This special report is the last tool I have at my disposal, which is why I submitted it to Parliament today. It's now up to Parliament to make the necessary legislative changes. The status quo is not working. Par conséquent,
I therefore recommend that Parliament refer this special report for study on a priority basis to either of the standing committees on official languages. I propose different options to modernize the enforcement scheme for Air Canada in order to help guide official languages parliamentary committees in their examination of this report. In particular, amend the Air Canada Public Participation Act in order to uphold the language rights of the travelling public and Air Canada employees in the airline's current structure, and strengthen enforcement of the Official Languages Act in order to improve Air Canada's compliance.
Air Canada says that its obligations under the Official Languages Act put it at a disadvantage compared to its competitors. Air Canada believes that the solution is to make the Act applicable to all airlines. In my view, a better indicator of success would be a more effective enforcement scheme for the Act that is better adapted to Air Canada's reality. However, despite our disagreements, Air Canada and I are in agreement on one thing: the government should act. Avant de quitter mes fonctions,
As I near the end of my time in office, I think it is important to bring this issue to Parliament's attention and to propose possible solutions. It is now up to parliamentarians to address this issue. This special report clearly demonstrates that despite the interventions of the Commissioners of Official Languages, Air Canada has been having problems complying with the Act since 1969.
in order to protect the language rights of the traveling public and Air Canada employees. Thank you. Je vous remercie. I'll be happy to answer any questions you may have.
Merci beaucoup, Monsieur le Commissaire, pour votre présentation.
Thank you very much, Commissioner, for your presentation. We will start off this first round of questions with Mr. Généreux. Thank you, Mr. Chair. Mr. Commissioner, on the subject of Air Canada, you recommend that one of the two commissions, or committees rather, on the official languages conduct another study. And yet, for the past 50 years, we can count all of the studies that have been done about Air Canada. There are many of them. Would it not be wiser to take action straight away without having to study this question once again in committee? If the committee agrees on a motion calling on the government to take immediate action, wouldn't that be a better solution? Well, if there were a bill, it could be tabled in committee to be discussed. Or, if you choose a different path, you could discuss that in committee. I mean, I'm not asking for a study. I'm asking for decisions to be made by the committee. I was very happy to see that the Minister of Canadian Heritage and the Minister of Transport showed an interest in this study. And the Minister of Heritage even said that she would be happy to collaborate with the committee on this. So I think that this issue is sufficiently complex that it requires, at the very least, a discussion of a bill. Now, there are 4 bills that died on the order paper. The situation has changed significantly since the first bill was tabled. I believe it was tabled by the MP Stéphane Dion in the last legislature, and it died on the order paper. Mr. Dion is now a minister in the government. Was his previous decision to table the bill a good one? Well, I think so. I think that as a former minister, Mr. Dion believed that the Supreme Court's interpretation or that the Supreme Court had identified a conflict that hadn't existed when the Montreal Convention was adopted. The government never thought that the Montreal Convention would take precedence over the Official Languages Act. So his bill was intended to ensure that the Official Languages Act would take precedence over the Montreal Convention. And we had made the same argument. That this is a quasi-constitutional act that should take precedence. And the Supreme Court, or a majority of judges on the Supreme Court, disagreed. They said that the Montreal Convention would take precedence as an international convention. So the bill was a response to that decision, and it reflects our position that we defended before the Supreme Court. Now, concerning your report, you said you were concerned about things being taken for granted. Do you think that Air Canada takes official language rights for granted and that's why they don't discuss it? Or what is your perception about what Air Canada considers to be its obligations and also its daily reality? Because if I've understood, they had, was it 40 million or 20 million passengers per year? 42 million passengers per year. And there were approximately 50 complaints. So now, I don't know what the answer is here, but would you consider that to be a good score or a very bad score? Well, I'm hesitant to use complaints as the only performance indicator here. Something that has always struck me is that when Air Canada's service to the public or to passengers is evaluated, or when it was evaluated in 2010, and when there was a follow-up in 2015, it became clear that only one of our 12 recommendations had been implemented.
I don't want to speak for Air Canada, but what I believe, what I observe, I should say, is that, first of all, there's been a great deal of investment and a genuine effort to ensure that all Air Canada flights taking people anywhere, from anywhere to Vancouver for the Olympic Games did have service in both official languages. I had some hope that that investment and effort would have led to the provision of greatly improved bilingual service, but what we saw in our review is that employees believed this was just for the Olympic Games and that there was no need to continue after the Olympic Games. When I told that story to the board, they said, no, we never said such a thing. But that was the message employees got. So I think there's a lack of communication, occasionally manifested in lack of respect or disdain or that perception, lack of respect for people who request service in the other official language. And that's the attitude that will trigger complaints. When people are treated with disrespect, they react to that and they look for ways to respond. In the Air Canada release, they said that surveys had shown that 94% of employees surveyed were satisfied. regarding the language service they could provide, but they wanted to use this. So 6% of people, 2.5 million people, weren't satisfied. The survey didn't show whether the respondent was francophone, anglophone, or bilingual. But it shows that a large number of passengers were not satisfied with the language services, what the language services were provided in. Thank you for your explanations. After the Olympic Games, Air Canada should have been delighted that Quebec wasn't getting the Winter Olympics. Do you know what I find startling in all this? Air Canada has its headquarters in Montreal, and that is the bilingual city, whereas French is spoken more in Quebec City. The recommendations you and your predecessors put forward, you've put 12 recommendations forward, and one has been taken seriously. I was an Air Canada customer. I am an Air Canada customer, and I do want to be spoken to in French, but since I leave from Montreal, it's not that difficult. Aside from a slap on the wrist, what are the consequences for Air Canada since they don't take French into account the way they should? We have used a number of instruments. There are no fines, so there's nothing people can understand, like a fine that goes up by 5,000 at every offense. One of the options we put forward in this report is fines. Consequences for failure to comply with directives. Normally, when you don't go by the rules, when you break the rules, there are consequences. We put forward a range of options, including the possibility of imposing fines. We also suggest entering into agreements between the Office of the Commissioner in Air Canada. If an agreement is established that protects Air Canada from court challenges for a number of years, but if, of course, there is no compliance with the agreement, there is the possibility of judicial recourse. There are a number of options that we suggest you examine. Each of them has its pros and its cons. Given that we're in Canada, a country with 2 official languages, would you suggest broadening the official languages requirement to all airlines? That was proposed by Air Canada. They took care to elaborate on that and formulate a proposition. They propose a bill. So if you feel that we should impose linguistic requirements on all carriers, that's up to you. I was hesitant because I thought that if it was difficult for Air Canada, it would be even more difficult for other carriers. What I find regrettable is that since Air Canada's headquarters is in Montreal, they already have an advantage. And we are still not seeing the result. If another carrier if there is another carrier with linguistic obligations, it's Via Rail. And they have been very insistent on pointing out that their ability to serve customers in both official languages brings added value to the company.
Il y a certaines problématiques d'élargir ça.
There are problems with
Air Canada
broadening the requirement.
ont fait du progrès. C'est vrai. Quand on
When Air Canada says they've made progress, that is true. When we look at the number of complaints 20 years ago, there were more than there are now, so there has been some progress.
malheureux, c'est
What I find unfortunate
qu'au lieu de prendre
is this.
notre vérification et nos plaintes
Instead of taking our audits and our complaints and using them as instruments to improve their performance, they're very resistant
à l'idée qu'ils aient
to the notion that they
systémique.
have a systemic problem in the first place.
Nos employés font affaire
The employees with whom our employees deal with,
à ce niveau-là.
we have good cooperation, but we can see the tone of their responses and the tone of the response of the Air Canada Legal Counsel, which we've included in our report. Thank you. We hope that there'll be bilingual Olympics in Quebec soon, and Air Canada will provide good bilingual service. Mr. Choquette. Thank you, Mr. Chairman. With regard to the Air Canada report, I really must congratulate you. Not only have you produced an extremely detailed and well-structured report, you provide tangible solutions for lawmakers. I'd like to go back to a quote that you made in your annual report, that it was like going up an escalator coming down. That applies to Air Canada as well, I believe. I like the fact that you're not comparing Air Canada to another airline, but to Via Rail, which is another carrier that was privatized and is meeting its official language requirements well. You say at the beginning, Keith Spicer said, language reform doesn't just pose technical problems. There is no problem that it couldn't solve if it had the right attitude. Keith Spicer said that in '76. We have invited the president of Air Canada, who doesn't seem very keen to appear before parliamentarians. What would you say to that? My view on the president of Air Canada's reluctance to appear before you? Well, I would say that you have the power to ensure that the people on whose work you have an impact can be required to appear before you, and I think you can use that power. Thank you. I'd like to clarify something that has been mentioned, that others have said as well, that it's time to act. What you recommend isn't a long study on what Air Canada is doing, but a study on a review of the recommendations to see which the best would be. You said that Stéphane Dion's bill applied only to international flights, and yes, they're important, but they're not the only thing. I'd like to come back to your first recommendation, the enforceable agreement. Why is that so important? I'm not just thinking about Via Rail, but many other situations. Recommendations have been made to give the Commissioner more power so that your recommendations would be more enforceable. Can you give us any details? Well, what a binding agreement would mean, that's something I'll refer to Pascale Giguère, because she is more of an expert. Regarding the notion of more power, I've been asked that question quite often, and I've always answered that I wanted to use all the instruments available in the existing legislation before beginning discussion on new powers. I also wanted to pave the way for my successor. So I think this is a good time to talk about this, now that there's going to be a new commissioner. But on the issue of enforceable agreements, at this point, when we do an investigation, when we investigate Air Canada, for example, we can recommend that they take certain measures, and Air Canada can also, during the process, submit action plans and commit to taking some measures. An enforceable agreement is what its name says. It is enforceable so that the organization arrives at the result desired. So, under an enforceable agreement, the institution would have agreed to take certain measures, and if it failed to take such measures, then legislative amendments would provide for a court order obliging the institution to fulfill the commitments it had made. If I understand correctly, in 2010, those were the last recommendations you made in Air Canada in 2010? Yes, we made 12 recommendations rather in 2010. And we said we were satisfied with the implementation of 1 out of the 12. So this is why you are now taking action so strongly. Out of the 12 recommendations you made, only 1 has been satisfactorily implemented. So there'd be more teeth with an enforceable agreement in situations like this. We're looking at an organization that does not seem to wish to comply with the legislation. In B, you also bring up statutory damages. Could you explain what you mean by that? Once again, I would ask Madame Giguère to provide details on these options. Thank you. Statutory damages. At this point, when a complainant takes it to the federal court, the court has the ability to award damages, but the complainant has to show that he has been subject to prejudice as a result of a violation of his rights, and that can be quite a stringent requirement. With statutory damages, the legislation would provide for violation of rights automatically to give rise to damages, and there would be a range, a certain number of breaches, certain kinds of breaches would lead to damages within a range. So this would take away the burden of proof. The complainant would not have to prove that he had suffered prejudice. This is an instrument with more teeth than what is in place now. Mr. Arsenault. Ms. Giguère, very quickly. Do I have 6 minutes? Oh, excellent. The case before the Supreme Court of Canada, could you tell me what was debated and what the court's ruling was? The case that went to the Supreme Court was a Canadian traveler who wanted service during an international flight. The federal court awarded damages to the complainant. The Federal Court of Appeal overturned that decision, and the Supreme Court found that because of the Montreal Agreement, which is an international agreement on the issue of payments to people who initiate legal proceedings against airlines. It limits the possibility of appealing when it in cases touching on international flights. It found that in this particular case, the Montreal Agreement superseded the Official Languages Act in this instant. There was, however, a dissenting report stating that the Official Languages Act was quasi-constitutional in nature and that Canadians should not lose their linguistic rights when taking a flight outside the country. And that, of course, was our position, you will understand. But the majority of justices on the Supreme Court did not accept our position, but rather the position of Air Canada, that the Montreal Agreement or Montreal Convention superseded the Official Languages Act. I would ask Madame Giguère whether she has anything to add to what I said. No, that's absolutely correct. I might add that this was the first time in Canada's history that the issue was put that the Montreal Convention was up against the quasi-constitutional Official Languages Act. Twice before, there had been cases involving the Warsaw Convention. The Supreme Court relied heavily on rulings by the United States Supreme Court and other high courts abroad, which had studied the Montreal Convention in their own legal systems, and there was no ruling, however, that involved a quasi-constitutional act such as the Official Languages Act. So the Montreal Convention supersedes or takes precedence over the Official Languages Act. That was for an international flight. But for domestic flights, the Montreal Convention would not apply. That is correct. I don't want to repeat what Mr. Choquette and Mr. Généreux asked, but if before me I had the President of Air Canada, I hope that does happen. How can we respond to his argument saying that the number of passengers is going up and up and up, and with so many millions of passengers, there are only 52 complaints? 52 complaints with 42 million passengers. But we're talking about rights here. The figures that they use in their communications, 6% of passengers were dissatisfied. That survey doesn't show how many Francophones were surveyed, but 6% of that 42 million is a critical mass. It's 2.5 million passengers who were not satisfied with the linguistic service provided. So I believe that I would have questions on how, in spite of all the years and all the recommendations that have been made after the review, how is it that improvements at the airport aren't happening? Why is there not a corporate culture, the kind of corporate culture that promotes the policies, the bilingual policies, and why that corporate culture doesn't filter down to employees that are supposed to provide bilingual service? You are all members and you travel and you all have your own experience that attests to the kind of service that you received. Some Air Canada employees provide exemplary service and are clearly proud of giving exemplary service, while others have no knowledge of how to refer a request for service in French to a bilingual colleague in a different part of the plane. So it's not just a legal vacuum. There's a communication vacuum, a communication gap between the policies and the delivery of service. Thank you, Mr. Chairman. Say that this is the second time in the history of your office that an official languages commissioner is tabling a special report to Parliament. Your report states that in 45 years, every commissioner that has looked at Air Canada is saying more or less the same thing, and there is nothing new. That's right, I keep repeating myself. Well, 45 years later, the problems are still there. You talk about amending the Air Canada Public Participation Act. How do you suggest that act could be amended? Is it to add fines? You also suggest enforceable agreements. Well, that's one component of what I suggest. Another that's even more important is to go back to the fact that 4 bills died on the order paper, 4 bills that were targeting Air Canada after restructuring. For example, Jazz is not subject to the Official Languages Act, but Air Canada's investment in Jazz, and given that Jazz acts as a third party for Air Canada in some regions of the country, means that Air Canada ultimately has responsibility for ensuring that Jazz complies with its linguistic obligations. With corporate restructuring, we've seen that many employees have lost their right to work in French. So the Air Canada Public Participation Act also applies to its subsidiaries, or we could make it apply to its subsidiaries. Via Rail is subject to the Official Languages Act? Yes, it is. Why is this then less of a problem for Via Rail than Air Canada? I wonder. That's exactly what I'm asking myself. What mechanisms has Via Rail implemented within its corporation so to ensure that it can be bilingual on a practical level? I think that question should be put to Via Rail. I had an informal conversation recently with someone who spent part of her career as legal counsel with Via Rail. And I paid her a compliment and said that we very rarely received complaints. And all the passengers I saw who were traveling on Via Rail felt that linguistic performance was excellent. She said that they work very hard to ensure that. Via Rail is almost independent. They don't have any competition, really, and could pretty much do what they wanted. And yet they managed to maintain a level of bilingual service that Air Canada doesn't. 6 minutes. That's 6 minutes up. Thank you.
Would you like to finish the time? Yes, if you allow me. There's so many good colleagues here on the Hill. We might as well share our time with each other. Now, you had mentioned a legal vacuum concerning the restructuring of Air Canada. Could you give us a little bit more detail about that? Well, I'll try to do so. Now, with the restructuring of Air Canada, there are aspects of the new structure that may not meet the obligations of the law. Perhaps Ms. Giguère can elaborate even more on what I've said. Yes, well, briefly, Air Canada's structure changed in a significant way in 2003-2004. Certain services that were provided by Air Canada, including many domestic flights, were taken over by other transporters, other carriers, like Air Canada Jazz. Many stations across Canada were closed. So a lot of these services are now being carried out by Jazz, and there were a lot of employees that also went to Jazz, and they had different language of employment laws. So, for example, luggage handlers and other employees lost some of their language rights following the restructuring. So that was the legal vacuum caused by the restructuring. Normally, that should have been followed up with legislative changes so that the linguistic rights would be maintained by Air Canada. And the same applies to passengers who previously had more linguistic laws under the Air Canada structure, but who lost some of those following the restructuring. So Air Canada has the obligation to uphold the rights, the linguistic rights of both employees and passengers following restructuring. And I would just add that in those cases, these were employees who were performing the same work at the same site with the same supervisor, but who, because of a corporate change at a much higher level, lost their right to work in French overnight. Precisely. So again, it comes back to leadership and to attitude. To me, it should be obvious that the rules of the game should stay the same. The official languages laws should be respected. For example, if I'm a plumber and I get a big contract and I choose to subcontract part of the work to a different company, well, they don't need to respect the rules of the game? Well, no, of course that's not the case. So that's my point about that. Maybe I'll use that analogy in future interviews. I think that's a good example. Well, my father was a plumber, my brother's a plumber, so plumbing is the example that automatically comes to mind for me. Do I have time for another question? No, we might come back to you for a couple minutes later, but I'm going to go over to Ms. Boucher right now. Thank you. Good afternoon, Mr. Fraser. You know, earlier you said that you'd been there for 4.5 years, but I really feel that the same subjects are coming back over and over, especially Air Canada. Ever since I started on this committee, that's what we've been talking about. And Mr. Sanson, I feel like you're really filling the shoes of Yvan Godin here. And that's a compliment, because he was a real fighter when it came to language rights. Now, I was in Vancouver 2 weeks ago for a convention. We flew from Montreal to Vancouver, and on the plane, the girls working on the plane, the flight attendants, were unilingual Anglophones. Now, somebody asked for a glass of water, and they answered, "I'm sorry, I don't understand." This is a flight from Montreal to Vancouver. When we flew from Vancouver back to Ottawa, the girls on the flight attendants on the plane were trilingual. The flight attendant who served me spoke 3 languages. So, what do we do with Air Canada? Do we need to change our attitude? Do we need a more proactive approach? Now, the government has changed. Many governments have changed, but this has been going on for 45 years. There have been bills, there have been reports, all sorts of things have been done. But now, perhaps Air Canada feels under attack. Every time we talk about official languages here, they might feel under attack. So in your opinion, what would be the best way to work with them proactively so they can really understand our message? This has been going on for 45 years. It's clear that we need to do something to make them understand. What do we need? Do we need fines? We need to tell them As of today, the government has decided that this is how it is. Well, you know, that's sort of the spirit in which I'm inviting you to take action on this. As MPs, you travel a lot. You can certainly observe the situation with your own eyes. What I would say is that sometimes you can see the effects of planning. For example, last year I attended the Canada Games in Prince George, and it's clear that the regular flight from Vancouver to Prince George is not designated as a bilingual flight. There aren't enough people using that route to require a bilingual service. But Air Canada obviously realized that with the Canada Games happening, there would be a substantial number of people, francophones, who would be going to Prince George for the Canada Games. And they made the necessary arrangements to make sure that that flight from Vancouver to Prince George would have bilingual flight attendants. So there's that example and the example of the Olympics as well. And in both of those cases, you can see that when there are strategic planning decisions made in advance, things go well. So where there are failures, I would say they are failures of planning, particularly when you see that there is a flight from Montreal to Vancouver or Montreal to Bathurst or Toronto to Quebec City. If there isn't bilingual service provided, that's a failure of planning. And the question that I would ask is what action plans, what strategic plans are going to be put in place, first of all, to ensure that there's a sufficient number of flight attendants who are bilingual on board, and secondly, what training will be provided to flight attendants who are unilingual so that they can carry out their functions. They don't need a degree from La Sorbonne to be able to understand someone who's asking for a glass of water. And they should have enough training so that if they're in a situation where they don't understand, that they'll know what to do. They can go get a colleague who speaks French. In the complaints that we receive, we can see that often unilingual flight attendants simply don't know how to handle someone who is requesting service in French. We've never asked any institution to employ 100% bilingual employees. The important thing is that there need to be enough people who speak French to be able to help employees that are not able to offer the service. Thank you very much. Mr. Sanson will have the last question. Again, it's a question of leadership. Go ahead. All right. Oh, thank you, Daryl. Now, this may be a legally naive question. I know that under the Official Languages Act, you don't have the power to prosecute people who violate their contracts, but in any case, I'll ask this. Air Canada was a Crown corporation that became a public corporation, and that's why it's subject to the Official Languages Act. That is not the case for other carriers in Canada. From the very beginning, those other carriers were considered private companies. So do you have the option of prosecuting in cases of contract violations? Would you have the possibility of prosecuting Air Canada if they violate their obligations? Well, I'm not a lawyer, So the difference between going before the courts in cases of non-compliance and then prosecuting actual contract violations, I don't know if I could explain that distinction to you. But as you can see in this report, there is a full list of the situations where I went before the courts and the situations where my predecessors did so in cases of non-compliance with the Official Languages Act. But when it comes to violations of contracts, I don't know. Okay, I understand what you're saying, but Air Canada's obligation to submit to the Official Languages Act was one of the conditions of its privatization. So that was between the government and Air Canada. The government subjected Air Canada to those obligations through the enabling statute. So unfortunately, we don't have the power to prosecute. That concludes the Commissioner's appearance before the committee. So first of all, I would like to congratulate you greatly once again for your courage and your vision in laying out these potential solutions to the committee. I would like to thank you very much for that. We will suspend for 1 minute, and then we will move in camera to have a private discussion. Thank you very much.